Good afternoon, everybody. This is John Hamre from CSIS, the president of CSIS. We're in Washington, D.C., but I think we'll have people watching all around the world. So wherever you are, good morning, good evening, good afternoon. We're delighted to have you join us. Today, we're going to focus on World IP Day. Now, World IP Day was actually yesterday, but this is like New Year's Day, and today we're all going to focus on, in a very sober way, what is the contribution that intellectual property plays in all of our lives? There's nothing probably more fundamental than this issue for each one of us. Every one of us is living in a world where we enjoy products that were manufactured half a world away. We're enjoying new technology. All of the foundation of that is based on intellectual property. And the question is, how do we protect the creative intellects that bring these things to market and give it to us as something that we can all use and enjoy? It's a remarkably vast topic, and it's unprecedented in its scale. It touches every one of our lives. And we're going to explore the significance of that today because there are a lot of issues associated with intellectual property that are swirling around but are not sufficiently well understood. So we're going to dig into that today in two ways. We're first going to hear from Senator Coons and Senator Tillis. These are two of the leaders in the Senate who are actually doing some real work thinking about these issues on behalf of us. And then we're going to turn to a remarkable panel of experts, and Kirti Gupta is going to be leading that. So first, let's hear from our two senators and their thoughts about it, and then I'll turn to Kirti Gupta to run the rest of the panel.
Hi, I'm Thom Tillis, Senator from the great state of North Carolina and ranking member on the Senate's Intellectual Property Subcommittee. In the Senate, I've been able to champion strong, reliable, and predictable IP rights. I'm committed to strengthening America's IP system to ensure that our country remains the premier destination for research, development, creativity, and innovation. This year's World IP Day rightly focuses on women and IP and their incredible contributions to innovation and creativity. Intellectual property rights are so important that our founding fathers put these rights in our Constitution. But it would take until 1809 before Mary Keyes became the first woman to receive a U.S. patent. It wasn't until 1870 that Olive Pettis became the first woman to register a copyright. These trailblazing women forged a path for countless women who have applied their ingenuity to improving our nation. Today, we celebrate and support all the ways IP can ensure the contributions of women are protected, realized, and shared with the world. Thank you.
Hi, I'm U.S. Senator Chris Coons from Delaware. Thank you to CSIS for the honor of speaking with you on a topic that's near and dear to my heart. As the co-chair of the Senate Judiciary Committee's IP Subcommittee, I'm someone who believes deeply in the importance of IP for America and our world. On this World IP Day, we celebrate the can-do attitude of women inventors, creators, and entrepreneurs, such as famous Delawareans, like Dr. Stephanie Kwolek, the DuPont scientist who invented Kevlar, a spun polyaramid fiber that's 5 times stronger than steel. Or Deborah Manis-Gardner, also known as the Queen of Sample Clearance, the go-to expert for global music rights clearances. Or Dr. Sitha Coleman-Kamala, who leads a nonprofit that identifies and helps destroy harmful chemicals in America's water supply. All three of these are great leading scientists, creatives, parts of the IP community in Delaware. But these stories are all too rare across our nation. In fact, one measure of IP diversity, the number of inventors on U.S. patents who are women, is less than 13%. This simply doesn't make economic or strategic sense. Increasing participation by underrepresented groups of Americans in our IP system would, by some studies, quadruple the number of American inventors, increasing our annual GDP by nearly $1 trillion. And it would, of course, improve our global competitiveness. From 2016 to 2020, China's number of women inventors grew at almost twice that of the number of women inventors in the United States. We have to start to change the culture around invention and develop an IP ecosystem that promotes and encourages the participation of women. That's why I joined with my friend and Senate colleague, Senator Mazie Hirono, to co-sponsor her IDEA Act in the last Congress. This is an important first step. It would collect demographic information from patent applicants to close the gap that women, minorities, and others face in patenting their inventions and fully participating in our IP system. Thanks for a chance to speak with you. I am, as you know, a fan of patents, trade secrets, copyrights, trademarks, and I hope that you have a wonderful panel and conversation today on this World IP Day.
Thank you, Senator Coons and Senator Tillis, for those opening remarks. It is my privilege to moderate this panel. As one of the women inventors, I didn't realize only among the 13% and patent owners, with a panel of intellectual property superstars. So allow me to introduce the panelists and jump right in after those remarks to discuss the state of play in intellectual property today and where we are going on this celebration of World IP Day. So we are joined today by Judge Paul Michel. Judge Michel retired from being the chief judge at the U.S. Court of Appeals of the Federal Circuit. We also have Judge Kathleen O'Malley, who also very recently retired as a judge from the U.S. Court of Appeals of the Federal Circuit. We have with us Andre Iancu, who, and Judge O'Malley is now a partner at IRL Manila, I should have added, because Andre is there too now at IRL Manila. And before that, he was the Undersecretary of Commerce for IP, Intellectual Property for the United States, or Director of the U.S. Patent and Trademark Office. And finally, we have Dr. John Hamre, who is, you heard from him before, he is the CEO of the Center for Strategic International Studies, the Washington, D.C.-based think tank, and also the former Deputy Secretary of Defense, so real national security expert other than focusing on the IP issues that we are here about to discuss. With that, let me just launch right in after the senator's remarks. I wanted to start by asking you a question about the current legislative agenda for this Congress. We heard a little bit about the diversity issues, the focus on, getting more inventors into our ranks. But can you also discuss, some of the other current proposals on the table in this Congress, and what are the current underlying issues they relate to? Andre, can we start with you?
Sure. Thanks, Kirti, for the very kind introduction, and so good to be with my friends and colleagues, Judge O'Malley and Judge Michel and Dr. Hamre and you, Kirti. And thanks to CSIS for allowing us to put on this conversation. So let me answer your question, Kirti, in terms of the legislative agenda. Let me just start with saying that if we want to increase participation in the innovation ecosystem, we must have a strong, reliable, and predictable IP ecosystem, as Senator Tillis mentioned. Intellectual property rights and the innovation economy are inextricably linked. You simply cannot hope or expect to have a growing, robust innovation economy in the United States without a reliable intellectual property system. So if we want to add more inventors, more innovation, whether they are from existing inventors or to bring new participants into the system, if we want more women inventors or minority inventors or inventors of any kind, those inventors need to know that there is a reliable system out there that works and allows them to spend the time and make the investments necessary into this venture, because innovation is by definition a risky enterprise. It is failure prone, and then once successful, it usually is easily replicable. And without the rule of law and protections provided by the intellectual property system, it's very difficult to make those investments given the risks. Now, In terms of the specific legislative agenda, let me start where Senator Coons left off. There is no question that if we want to broaden the ecosystem to more women, minorities, and the like, we first need to understand the data. And there's a paucity of data in terms of where innovation comes from in the United States. And the IDEA Act that was introduced by Senator Hirono would really help the Patent and Trademark Office to gather that data from its applicants. And it's something that I support, and hopefully it gets reintroduced again this Congress. It's a small step, but it's a really important step, because if you care about improving, you first need to know what the current situation is. Now, in terms of other substantive pieces of potential legislation, I break them into four major topics. First, patentable subject matter. Section 101 of the Patent Code. This area of law remains substantively very confused, and it's the result of Supreme Court decisions about a decade ago, and then the way they've been interpreted by the Federal Circuit over the ensuing years. It's leaving the patent system in a mass of confusion as to what's in and what's out. And most importantly, this is damaging the technologies of the future, such as biotech, artificial intelligence, and the like. Senator Tillis had a bill last year to fix Section 101. It's a good bill, and hopefully he reintroduces it again. And Senator Coons has indicated in the past that he would be a co-sponsor of that, making it a bipartisan bill. Second, the PTAB, the Patent Trial and Appeals Board, which was created through the America Invents Act that was passed and signed into law 10 years ago or so, and post-grant proceedings, validity challenges of issued patents that the PTAB undertakes in the form of IPRs, and PGRs remain controversial. And there is a lot of confusion as to how that process goes. You don't need to go further back than just last week. The PTAB released an advance notice of proposed rulemaking with dozens of potential proposals, seeking comments from the public on dozens of potential proposals on how to address the PTAB. I believe it's incumbent upon Congress, now having seen 10 years of the America Invents Act and how it works, Congress should come back and tighten up that legislation so that it becomes more reliable and predictable for the public. Senator Coons, in the past, has had a bill called the Strong or Stronger Act. He has said recently publicly that he plans to reintroduce a new version of that, potentially in a different format. So we look forward to seeing what that might look like, and hopefully that would get bipartisan support from Senator Tillis and potentially others. Next is injunctions. And we can talk a lot more about all of these things. But the Supreme Court, maybe a dozen years ago, in the eBay v. Merck Exchange case, has laid out a set of factors to consider when injunctions are to be issued. The end result, a decade later, is that injunctions are very difficult to obtain in the United States, even if a patent is found to be valid and infringed. That reduces dramatically the value of patents. The fact of the matter is that patents are property rights, and the quintessential feature of any property right, whether it is a piece of land or a house that you own or a piece of personal property that you own, The quintessential feature is the right to exclude, telling others you don't have the right to trespass on my property. And when it comes to patent rights in the United States, that quintessential feature of a property right is by and large unavailable right now. Mm-hmm. And in my view, that needs to be fixed through legislation. We did fix it on the trademark side in 2020. In December of 2020, Congress passed and the president signed into law the Trademark Modernization Act, which has part of the feature to ensure the right to an injunction in trademark cases.
Andre, let me pause right here for a minute, because that's a lot to chew, and we will come back to you on other legislative proposals on the table. But really what you're laying down here is some of the quintessential pillars of having an intellectual property system in the first place. We'll talk about expanding the landscape and diversity later, but really what you're talking about here is the ability to get patents, that is 101, subject matter, the ability to keep those patents valid, that is, the challenges in institutions like PTAB. And then the third is, once you get them and they're valid, then how do you enforce them, the injunctions? And all of those three seem to be needing quite a bit of systemic reform right now. So, before we move on to some of the additional things on the table in terms of legislation, Judge Michel, I would like you to jump in, quickly, your views on this. And while you're, thinking about this, also just yesterday was World IP Day, right? IP matters. If you can put this legislative agenda in the broader context of why does IP matter, that would be great.
Well, Kirti, I think the starting point is that we live in a global economy to a great extent. We're in intense competition with friendly countries like those in Europe, who are competitive rivals in commercial areas. And we live in a world of an intense competition with potential adversaries, particularly now China. And therefore, the reality is we're facing challenges from Europe, which has greatly improved its patent system while we've weakened ours, and from China on the strategic level. China has also greatly improved its patent system. So, for example, inventions that are no longer eligible in the United States because of Supreme Court decisions are eligible in Europe and in China. Injunctions that are so difficult to obtain here in the United States are routine in Europe and in China. So we've put ourselves at a huge competitive disadvantages by tinkering with the patent laws in an uninformed way. The worst tinkerer turned out to be the Supreme Court, which does not have the expertise, the experience, or the insights into business decision-making, investment, incentives, and the like to be able to sensibly make national innovation policy, and they shouldn't do it anyway because they're unelected. That's the job of the elected representatives in the Congress. So in short, IP matters because it's the underpinning of our economy and our national security. And in today's world, economic security and national security are almost one and the same.
One and the same thing, yeah.
So we need to fix up our system, and it pretty much has to be done by the Congress because the courts have trapped themselves in bad precedents, which have this heavy forward effect because of the legal doctrine of not redeciding things previously decided. So it's pretty much up to the Congress to bail out our economy and our national security.
So one question quickly back to you, Andre, and then I want to ask Judge O'Malley something. But, Judge Michel is basically agreeing with you. He's saying that, getting patents 101, subject matter eligibility, has become an issue while, there's other trajectory in China, which is, quite the opposite of what we're seeing in the United States. Keeping those patents valid or maintaining the validity through these challenges is an issue. And then finally, enforceability or injunctions is an issue. So is the legislation that is on the table on the right track? Are these all, useful? or are there other things that we should be concerned about that are also on the table?
Yes, they would be very useful, Kirti. So the 101 bill from Senator Tillis that he already introduced last session looks very good, and obviously improvements can be made during the legislative process, but it's a very good start, and hopefully he reintroduces it again. We haven't yet seen an introduction of the PTAB reform bill from Senator Coons, or the or the injunction bill from Senator Coons. He has said publicly that he intends to introduce both of those, two separate bills, but we haven't seen them, and hopefully he will do so. And I suspect, knowing where it's coming from, that it would address those issues. Mm-hmm. There are plenty of other things to discuss in terms of legislation, but I will just say at the high level on the one of the biggest problems in the United States is enforceability. It's basically death by 1,000 cuts for patents and patent owners, and the judges can talk more a bit about that. But this is the issue. You need to have a system that is obviously strong, reliable, and predictable, but there's a fourth thing. It needs to be meaningfully enforceable. In other words, practically speaking, you need to be able to actually enforce those patents and hold infringers accountable. And if that doesn't happen, then patent value is diminished. And hopefully the legislation will fix that.
Okay, so that's a perfect segue for you, Judge O'Malley. So death by 1,000 cuts for intellectual property owners. Could you tell us a little more? Have you seen that? And also, let me just play the devil's advocate for a minute, because both Hamre and Judge Michel have painted this picture of the United States having gone down this path, maybe over the last few decades, where it's hard to get patents, hard to have the validity, and upheld or to enforce them even. How much does this matter? Can innovation be done in a different way? Do we really need these? Or, as somebody would say, is intellectual property the only or an important way to innovate? And the 2020 line, you need to unmute.
Thank you. You'd think after all these years I'd have that down. But intellectual property protection is critical to innovation. I mean, Andre and Paul have already alluded to these facts, but yes, though innovation will occur in countries like China, where it's all paid for by the government, where all research is paid for by the government, and no one's really taking any individual risk. But when you have a market economy where innovation has to be funded either by large corporations or by wealthy individuals or venture capitalists, there needs to be an incentive and a protection for those who are undertaking that risky behavior. Innovation is a risk. I mean, for every new medicine that goes through phase 3 clinical trials, there are thousands that never make it that far. And these are expensive propositions. So there has to be some kind of market incentive for individuals to innovate. Yes, young gamers might still, make games, but that's not the kind of innovation we need to be concerned about. We need to be concerned about critical infrastructure innovation, medicines, and other innovation that will ultimately protect all of us and make all of our lives better. This goes all the way back to the founding fathers. When this country was formed, all we had were poor individuals who the founding fathers realized they needed to incentivize. And they wanted to incentivize their innovation by democratizing the system. And so what they said is, unlike back in England, you don't have to practice your invention. You can just be an inventor, and you can then license those inventions. I mean, the reality is our founding fathers created non-practicing entities for a reason. What they did was they made sure that innovators could make it a way of life. I mean, Goodyear never did anything other than license his innovations. Tesla never did anything other than license his innovations. We have a whole history of amazing inventors who today you would call non-practicing entities, because they were able to go back and keep inventing because they were able to license their creations. And the founders are right. Our then nascent economy did grow, and it grew on the back of these kinds of innovators. And that's what we need to do. We need to keep incentivizing everyone with a good idea, and not just large corporations.
Like as economists, we would say that imagine the dead weight lost to society if we didn't have the Teslas and the Goodyears of the world putting their ideas on the table and letting others use and build upon them. So what is this death by 1,000 cuts that, in your experience, you have seen as a judge that IP and patent owners are facing today?
Oh, it's horrible. I kiddingly one time said the worst thing to be is a patent owner, because you get attacked from every single angle. So there's the post-grant review proceedings, the PGRs, the IPRs, there's all the other, first you have to go through the process of getting the patent, which is ugly. And the examiner often rejects and rejects and rejects, and it takes forever and a lot of money to keep going back. Then you've got to pay your fees for your patents while you're being attacked. And then you turn around and someone's copying you, and you decide to enforce your patents, and then those individuals will both fight you in court, and they will make sure that some kind of post-grant review is filed at the same time. There's so many different fora in which you can attack a patent. I mean, there's the ITC even. So what happens is patent owners are being attacked from every front, and in the meantime, they have built their business on these patents, and so the businesses are suffering. And we've got to find a way to stop that. I mean, I know that there was criticism of the patent system before, when they thought there were too many lawsuits being filed by small inventors or those who weren't practicing their patents. But that was a small problem compared to the problems we've created. The fix has been far worse than the problem was. And there were other ways to deal with those problems.
One of the things that you were saying, and I want to draw that out a little bit, you were saying, well, there are some people who will keep inventing, like, the gamers will keep building gaming apps, but so some kind of inventions may not be reliant on the intellectual property system or patents as much, but then there are a slew of others that are, and, you gave some examples of some of these foundational technologies, like the ones that Tesla and Goodyear were working on. And I think that's sort of important to unpack, especially at the intersection of the current geopolitical context and global competition, the world we are living in, that Judge Michel alluded to. So Dr. Hamre, let me turn to you. So, for some technologies, this matters. So how does this world of intellectual property intersect with national security? What technology areas matter for national security, and will innovation in those areas suffer without strong IP protection?
Thank you, Kirti. This has been a masterclass listening to these remarkable teachers. Let me just say, there are two answers to the question. I think the first thing we have to say is that we've got two different levels of national security. I'd say one is capital N, capital S, national security. Another was small n, small s. The small n, small s, that's the aircraft carriers, the bombers, the weapon systems we buy. That's small capital NS. The capital NS is the vitality of our economy, the strength of our innovation system, the creativity in the innovation system. That's really the foundation of national security. And so if we're going to compete effectively in this new era, we have to have by far the strongest economic foundation, technology foundation. And for that reason, I think it's a crucial national security issue that we have the strongest intellectual protection rights, so that people will invent, they will create. And we're going to depend on that. Now that brings me to the small n, small s, national security. the traditional defense things, the bombers, the aircraft carriers, etc. A very important transition occurred over the last 50 or 40 years during my lifetime. When I first started off in defense 45 years ago, the Defense Department funded advanced technology in America. And it put vast amounts of money into the economy, and it helped create, government spending was behind all of everything in aeronautics that we enjoy today, airplanes. It was behind the genome. I mean, DoD funding was behind the genome, and Department of Energy funding was behind the genome. It was actually started in a weapons lab, if you could imagine that. But today, now 45 years later, all of the innovation in America is coming in the private sector. And it's the government that needs to now use the creativity in the private sector for small n, small s, real important, because today, combat activity depends on coordinating vast amounts of information and using it effectively. That's in the private sector. So if we're going to succeed, we need to have the healthiest and strongest private sector in order to protect national security, both large NS, small NS.
And it's like what Judge O'Malley was saying, right? That we are a market economy. In a market economy,
Yeah.
we don't have this incentive structure where we're getting these massive subsidies from the government, or we're allocating funds in a certain way to drive the R&D. That's just not happening anymore. So how are people coming up with ideas and monetizing them? Well, first, by either taking that intellectual property and licensing it broadly for others to use, or using it for your own products and becoming vertically integrated, and then you create another like large, big platforms. But those are all important mechanisms. You can't, kill any one of them without hurting the nature of the innovation economy, the marketplace.
Kirti, could I just take a second to amplify on what you just said? I think the most important decision that we made to win the Cold War was a decision that was actually made 35 years before it started. And when airplanes were first being invented, we were faced with a question: do we put the aircraft industry into an arsenal and build it inside government arsenals, factories, or do we keep it in the private sector? We decided to keep it in the private sector, and that led to an explosion of innovation that gave us the best quality military hardware in the world. We absolutely have to keep it in the private sector.
Kirti, if you don't mind, let me just jump in here for a second. And I fully agree with what Dr. Hamre just said. But it's important for our audience to understand that that will not happen. Putting it or keeping it in the private sector will not happen for the technologies of the future without a reliable patent system. Those two things are inextricably linked. Members of Congress cannot walk around the halls of Congress or speak publicly and say, I support American innovation. I want more American innovation in these areas of technology. I want private industry to participate at its full capacity, and at the same time, vote for weakening intellectual property laws. Those two things don't go together. If you want a strong private sector innovation economy, you must be for strong intellectual property rights. And the reason for that is because if all these technologies, especially of the future, like AI, like biotech, require huge upfront investments, and they are risky. 9 out of 10 times they fail.
Right.
And if they succeed, there has to be a mechanism through the rule of law that those investors who have risked their capital can reliably recover it. That is why you need a strong IP system that's meaningfully enforceable at the end of the day. So it's really important to make this connection between innovation and IP.
And this is the link. Thank you, Andre. This is what I wanted to draw, because, I like to say as an economist, the world's an efficient place. if we don't remunerate, or if there is no return on certain kinds of investments, then those investments are not going to be made. And then the question is, how much is that hurting our national security interests? And thank you for pointing out some of these technologies of the future, or they're actually here and at a very fast pace developing, like AI and quantum compute. Biotech's one of them, 5G, 6G communications is one of them. And I think that, I would love to hear a little bit more about how they're actually being affected today, now, with some of these challenges that you all have been talking about: death by 1,000 cuts, enforceability, getting the patent in the first place, and then keeping it valid through all these multiple challenges in multiple fora, like you explained, Judge O'Malley. So, drawing that linkage a little bit more closely to some of these critical technologies that matter for national security, and what is the real world effect today from some of these IP challenges you are facing and you're talking about as legislative fixes.
Verdi, could I take that at least to begin? We are in a situation now where you have to look carefully at the flow of money, corporate money and venture capital type money, outside funders or inside funders. The people who manage those flows of money have fiduciary responsibilities to themselves and to others. And they have many, many options. They don't have to invest in artificial intelligence. They can invest in movie making or building hotels or casinos or all kinds of other things.
Right.
And they also are not required to invest the US source capital in the US. Money is mobile. They can invest it elsewhere. And what we're seeing is increasingly venture capital money that originates in the US used to stay in the US. Now it's increasingly going overseas to many other countries, including, of all places, China. So if you watch these money flows, you see we're driving toward a cliff, and we need to turn around and protect the incentives so that the money stays here and gets invested in the critical technologies, the foundational technologies that have been mentioned, and others too. It's that simple. If the money doesn't stay here and go into where we need it to go, China will dominate the world economies, including ultimately our own, and they'll dominate world affairs and world politics. And we are at risk of becoming a subordinate nation. It's all a question of incentives for investment in real tech.
Yeah,
So
Kirti, can I
old
add to
adage,
that?
follow the money. Yes, please.
Yeah, so because that's, I was about to jump in to say the same thing that Paul did this, and the studies are very clear. The first thing that happened was that we started losing venture capital in new technologies. Instead, it was all going to clothing and food delivery services, and it wasn't focused on the place where our country needs to focus, which is, as Andre pointed out, either biotech or all these critical infrastructure questions or places. And
risky investments.
Yes.
Investments. That's why you need patents there.
Exactly. And if you look where the venture capital goes, it almost always goes to an entity or person that has patent protection already. In other words, IP protection translates to venture capital investment. And nowadays, the venture capital investment is looking for not just IP protection, but in a country where IP protection is meaningful. And we do a lot of work with international bodies and people and judges from all over the world, and they will tell you that they look at us and they shake their heads. They say, why are you giving it away? They believe that, especially when it comes to the enforcement issue, that the Supreme Court's eBay decision was the beginning of the slide to take us from the top IP protection system to now way down. We are not the primary place for the protection of IP. It's now China, India. It's not happening here. And we have to get it back. And it's all this is going full circle, but this is going back to all those legislative proposals that Andre mentioned. If we don't undertake to recapture our standing in the world, we are going to greatly risk that capital and capital S national security.
So Andre, thank you, Doctor. Thank you, Judge O'Malley. Andre, quickly on that, I wanted to ask you, because you had talked about what's on the table in terms of legislation, and I think you're all making this very clear that we need those kinds of proposals on the table today, urgently, to bring this innovation engine back functioning. There are, like, I can't imagine that everything on the table in terms of a legislative agenda is helpful to that cause. Are there things we should also be vigilant or watch out for that are maybe in the other direction?
Yes, absolutely. And there's always a bevy of proposals, both in Congress and in the administration, that would be harmful and go in the exact opposite direction for the innovation economy that we have been discussing. I'll give you some examples, right? There are thoughts and ideas on fixing, quote, the PTAB, but in a decidedly unhelpful direction, which would make it even more unpredictable and allow even more challenges from against the patent and further destabilizing the property right. There are all sorts of challenges to drug related patents. This is a very important point here. There is a lot of sentiment in Congress and in the administration that something needs to be done about drug pricing. And whatever people's views are on that, there is no evidence that the patent system is at fault for the current state of pricing in the pharmaceutical industry. So various types of proposed legislation and administrative action that would be very harmful to patents in the pharma space. And this is a very important point. As soon as you try to do something to weaken patents in one industry, it will have a broad-based effect on all other industries because the patent laws are agnostic as to the industry. So, for example, there's a proposal to curb the number of continuations on a particular patent application and in order to reduce the number of patents on a particular drug. But boy, messing around with the continuation practice in the patent space will have a broad-based effect in all industries, including climate industries such as battery technologies, semiconductors, and the like, and it will dramatically stifle innovation, definitely in the pharma space, but also in all the other industries. So we have to be very vigilant at all times to explain to folks that if you want a robust innovation economy, you cannot be advancing these innovation-killing initiatives.
Special rules for different kind of patents should be avoided.
Well, that's especially true, Kirti, because our treaties, all the international treaties that we have executed, say that we will not differentiate or favor one industry over another or one kind of technology over another as it relates to patent rights. So, I mean, it's not just a question of whether we should do it. It's a question of we're not supposed to do it. We have promised. And if we do it, then there's a great fear that there'll be actions against those same industries in other countries because they won't feel bound by our pledges.
Yeah,
of course, everything comes down to politics in the end. And in our country, politics is so bitterly divided on practically every issue, and that includes IP. There are enormous number of lobbyists and public relations firms and individual companies and whole industries that are working and spending vast sums to further weaken patent rights. At the same time, people who want to see patent rights and innovation strengthened are working in the other direction. So there's a huge battle going on, and a lot of money being spent. And it's not only in the Congress and the halls of Congress, but also in the Supreme Court. And in my view, the Supreme Court and the Congress over the last decade were basically sold a false bill of goods by anti-patent forces, usually super rich big companies that don't want competition, don't want new innovation. They want to hang on to their existing vast revenues and their market share. So they're trying to squelch upstarts, or sometimes we call them startups, who are critical to this innovation ecosystem. And it's so important for the policymakers in the White House and the Supreme Court and the Congress and elsewhere to realize that we will destroy our future if we don't revive, as you aptly put it, this great engine of innovation, the best the world has ever seen. It's what made us the richest, most powerful country. Not only that, but critically that. So winning this political battle is critical to the future of the country, short term and long term.
So this is a really important point. You know, for many of us, you know, startups, which are the engine of the economy of innovation, let 1,000 flowers bloom, are upstarts. If you are a large incumbent and you have a good hold on the market, and you don't want to be an IP supporter. And I think I would go so far as to say that maybe in the world, there is often a natural innovator implementer divide. In other words, there are very few creators and very few implementers of any kind of idea, technology, new innovation. Patents is no different. You know, I know this to be true in the 5G, 6G technology space, for example. So when you are then in an economy like that, then there is a natural imbalance, right, of the, you know, the kind of, you know, political positions and advocacy that you're describing, that there are just a few that need that, you know, engine to propel the patent system and all that, and many that see a short-term advantage in changing that, in implementing and reducing the value of that IP. Andre, any thoughts on that? Have you seen that in your running of the patent system, patent office?
I apologize, Kirti. Have I seen what specifically?
This innovator implementer divide, you know,
Oh, yeah.
few creators, many implementers, and does that play a role in this dynamic that Judge Michel was describing?
Yeah.
Politically?
Okay. Right. So what's interesting in IP in general, in patents in particular, these issues do not divide along traditional political lines. So you don't usually have Democrat-Republican divide or conservative, liberal, the traditional ideological divides. Divides in these areas do come around, do usually formulate around innovators, implementers, or different industries, depending on their economic needs at the moment. So depending on the technology, for sure, the folks who, on balance, innovate more than use the technology more will want stronger IP protections. And those who, on balance, implement or use other people's inventions more will want weaker IP protections in order to drive down the price of the innovations they acquire. What's really important for policymakers, whether you're in the administration, it was true for me when I was there at the PTO, and it's also true for legislators, is to rise above all of this divide and try to figure out what is good for the United States in the future. How does the United States on balance maximize its innovative output so that we can benefit our population the most and compete internationally? And here's what's really important for intellectual property and patents in particular. A balance is needed for sure. So you want to make sure you fully incentivize and protect the innovation, and you also have to make sure that there is access to that innovation, broad-based, So to maximize both the creation and then the transfer of that creation to the public. And for both of those things, having a robust and strong intellectual property system, a reliable rule of law, in other words, is critically important.
Yeah, to
Yeah,
be
thank-
reliable, it has to be predictable. It has to be stable. It has to be clear what's going to happen if you invest billions of dollars in an innovative enterprise. And the courts, unfortunately, and I'm embarrassed saying this as a former judge, have made it so complicated, subjective, unpredictable, and unstable on issue after issue that we've created the opposite of a clear-cut system. We used to have it. We threw it away because in the lobbying battle, the small number of very rich companies that mainly infringe have armies of lobbyists and PR firms and law firms. And the small new emerging companies, which are often the most productive, don't have those armies of lobbyists to fight this kind of battle. So it's a very unequal battle. And it's so wonderful that CSIS and other such institutions are looking at the national interest, as Andre emphasizes, and not just looking at the short-term interest of one industry or set of companies versus another. That's the only way we're going to get out of this trap we've put ourselves in.
This is incredible. So these upstarts, these startups, go ahead, Andre.
I just wanted to address something that Judge Michel just said, and you addressed here as well, because it's important for legislators and people on the Hill to understand the differences here, because they're going to hear a lot from one side and less from the other side.
Yeah, that's what I was asking, this imbalance.
It's an imbalance in the loudness of the voices, but again, people who care about the national interest at large, okay, need to rise above all that imbalance and recognize it. The reality is, for any creative sector, there are always more users of the creativity than the creators themselves. So for example, there are many more people listening to songs than the singers who make the songs. There are many more people who view the masterpiece paintings in a museum than the painters who painted those paintings. It's the same thing in the technical innovative sector. There are many more people who use technologies like in our iPhones or a drug than the actual scientists and engineers who make them in the first place. So therefore, in general, on average, the voices will be much louder from the people who implement the technologies because they want to drive down the prices than the creators themselves. But if you are in a public role, caring about not having a horse in the race and caring about the national interest at large, you have to recognize that imbalance so that for the future of the United States, we enable those creations in the first place. Because if you're going to cheapen and weaken the rights so much, many fewer people will be willing to invest their time and resources in making the creations and the innovations in the first place, and that would be bad in the long run for the United States.
And like Judge Michel was saying, you follow the money, and you see that that's already happening. You know, by the way, that's also true in the 5G, 6G standard space. My world, former engineer in that, you know, there are hundreds, 800 plus companies that come to the table and build these technology standards. But when it comes to contributing the technology, the creators, as you said, there are very few. There are less than 10 that contribute over 80% of the technology that forms these critical standards. And that's why you see this, you know, divide. And I know, you know, we've seen special rules on standards related patents in the United States, and the US has not gone down that path. We have actually steered away from that path, but we are seeing the revival of that kind of a proposal in Europe now, surprisingly, which is also a leader in these critical technologies. And we'll see how that plays out.
Can I add something to what Andre said? The sad irony is that there are several large companies who built their businesses on the back of patents, right, and who had the protection of patents as they were building their businesses. But now they are so large that they have vertical. They have vertical integration that they can rely on. They can prevent competition in lots of other ways. They can use trade
Correct.
secret protection. And so
Yeah.
what happens is those same companies who used the patent system to grow are now saying, we don't need a patent system anymore.
Because now the startups are upstarts for them.
Exactly. So those same companies, but what is their innovation? Their innovation is just one new iteration of the system. So one new cell phone, one new TV, but it's not coming up with something totally different. And that's what we need. We need the people that are going to think outside the box. And we can't let these companies who have huge boxes be the only voices that are heard. I mean, it shouldn't be a partisan issue. Look at this panel. We are appointees of presidents from different parties, and yet we all still see this the same way.
Right. And does that relate to this argument that, Judge O'Malley, you've been in the trenches on these battles on intellectual property, this narrative on non-practicing entities. And non-practicing entities are sometimes also universities and small inventors and startups, but bringing forth nuisance lawsuits, suing small businesses, mom and pop shops, looking for a quick buck via settlement. Where's that narrative coming from? Does that relate to this theme of this imbalance, few creators, many implementers?
Well, it's a false narrative. It's a straw man that was put up so that it could be knocked down. And even the Supreme Court bought into the notion. And yet non-practicing entities are universities and research labs. They are not just, I mean, yes, there are some bad actors in litigation. There always is. But there are ways to deal with that. The courts have always dealt with bad actors. I mean, you remember there was a whole battle for years all about these bad plaintiffs' lawyers. And that was a concerted effort to go after plaintiffs' lawyers across the board. And then there were studies that showed that the reality is that all of that was being paid for by the companies that wanted to prevent individuals from getting the protection of the courts. And it's the same kind of narrative. It's a loud narrative, but it's not a real one. All the statistics show that there's only a small percentage of lawsuits that are filed by non-practicing entities that aren't otherwise universities or research labs or small inventors who just keep inventing again. That this notion that there's a ton of abuse, I think is that's the problem. It's a false narrative, and there are ways that courts can deal with abuse that are already in existence.
Yeah, and that narrative has sucked up so much air and energy in Washington that is like deflecting from, some of the key challenges today, this competition with China. So Judge Michelle, you started talking a little bit about this. How is China utilizing its own IP regime? And, what are they doing to, I think you said a few times, bolstering their IP regime? Judge O'Malley, you alluded to that. Can you talk a little bit more about that?
Well, China has greatly improved its entire IP system, particularly its patent system. It's done it repeatedly over the last decade or so. Today in China, trials are very fast. They're in front of technically trained expert judges. They're very inexpensive compared to trials in the United States. As I mentioned earlier, I believe eligibility is wider and clearer in China than it is now. Injunctions that are rare now in America are routine in China as well as elsewhere. So on point after point, China is strengthening and getting the benefit of improving its patent system. And in the very same decade, we've been serially weakening and further hobbling our patent system just because of the political lobbying power of a small number of very rich companies who are taking a short-sighted view. Now, I agree with Andre that in the end, policymakers have to rise above parochial interests of this group or that group. But there's a second form of protection which seems to be missing among the policymakers, certainly among the staff on Capitol Hill. And I spent 9 years as a staffer at the Senate, so I have very deep memories of how all this lobbying stuff works. And you have to demand proof. You have to say, what are your statistics? Where are your studies? Where are your specific examples? You're saying that trolls are ruining the companies that you work for, but you're making more money than anyone and more than you made before. Where's the proof that you're being bled white by NPE lawsuits? And if the staffers don't demand the proof, they almost surely will continue to fall victim to the false narratives, as Judge O'Malley says, and to wild exaggerations. Yes, there are some problems, but when the solutions are vast overcorrections, the net impact is to hurt things, not help things. So the people in charge of the policymaking apparatus have to be skeptical. They have to be like the judges. Show me the proof. Don't just tell me, show me the proof.
Dr. Hamre, as a national security expert, what's your reaction to this trend that Judge Michel just described of China bolstering its IP system?
This has been a masterclass. I've been sitting here in awe of the four of you taking me into a world that I don't understand that well. But it's been both educational and alarming. What Judge Michel just went through is something that was absolutely new to me. And it shows the depth of maturity with the primary competitor. I'm avoiding the word opponent, but competitor that we face on the world stage. And ultimately, our national security strength rests on our economy. And I think he just outlined for me, this was absolutely new for me to hear this, but he's just outlined for me an understanding about a major new challenge we're going to face. It's not the next 5 years, it's the next 20 years, but it's going to be profound. And I wrote myself a note and I'm going to follow up on it because I think it's a huge new insight for all of us in the national security community that we need to think in a broader and more structural way about this challenge.
Can I add maybe a conclusion here to all of this is that time is of absolute essence here. I believe we have no time left to waste on this issue. We are in a crisis situation. Why do I say that? We are the cusp of the technologies of the future. We are on the cusp of artificial intelligence, and we see just recently the great strides that things like ChatGPT have made, and there's so much more that's forthcoming. We are on the cusp of quantum computing technologies, where computers are being developed that are going to be millions upon millions of times faster than the fastest supercomputer today. We are on the cusp of molecular engineering, at the beginning stages of molecular engineering technologies that are going to change medicine in ways that nobody has predicted even a few years ago. And then some of these technologies can be combined with each other. Imagine artificial intelligence driven robots that compute at quantum speeds, and then they can communicate with each other at 6, 7, 8G speeds. So the convergence of these technologies, of these new technologies all in one. The country, the society, the culture that gets there first, or in some or all of these, will control worldwide events easily for the next century, probably beyond. On all these new technologies, we are neck and neck with our adversaries, our economic adversaries and the like, and we need to do whatever we can in the Western world to maximize our innovative output so that we can enable our inventors and enable our countries to compete and compete for the continued leadership in these areas of technologies. Because if we don't, just a few years from now, we're going to wake up and say, what's happened that now all of a sudden somebody else has this lead and we cannot catch up? And in the Western world, in a free market economy, you cannot compete without a strong intellectual property system. If you want the United States to compete, if you're a legislator today, if you're in the administration today, and you want to compete, you must today strengthen and fix our IP system so that the innovation economy can get going and allow us to be competitive again.
Well, on that note, this has been a fascinating conversation, and I would like to invite each of you to leave our audience with one key takeaway. So this is quick fire drill style, one main takeaway that you want people to walk away with from today's conversation. I'll start with the way you are showing up on my screen, Dr. Hamre first, then Andre, then Judge O'Malley, and then Judge Michelle.
Well, start with the weakest intervention, and I think that's what I can offer. The next century, this 21st century, it could be the American century all over again if we get the foundation right. But we're not paying attention to the foundation. And the foundation was put in place. It needs to be updated, of course, with technology changes, et cetera. But the foundation is to build it around the private sector, the strength and innovation of the private sector, to protect and promote the creativity of that private sector, and let it help us build a stronger economy. We'll build a powerful military on top of that. Don't worry about the military. Give us a strong and dynamic economy, and we will prevail.
Andre.
Yes, thank you once again for hosting us, CSIS and Dr. Hamre. Thank you, Kirti, for moderating us so expertly, and an honor always to be with the panelists and the two judges and all of you. I can only repeat what I said a minute ago. Our leaders need to focus on this issue immediately. We have an upcoming presidential race next year. All the candidates, in addition to all the other policy positions they have, they need to develop and present to the country an innovation policy. And their innovation policy, their innovation positions must have intellectual property positions, because you cannot have one without the other. If you are for American innovation, you must be for strong intellectual property rights, a reliable system. The two are inextricably linked, and the leaders need to step up immediately so that we can rev up our inventors and our innovation economy.
Judge O'Malley.
I want to thank CSIS for giving our voices a platform, and thank you, Kirti, for moderating this. It's not just a question of acting quickly. I think the key here is to make sure we don't think too narrowly. We keep forgetting that when we push here, something gives here. So we think we're going to fix one little problem, and we oversize that problem, over-dramatize that problem, and we cause more problems. We think we're going to take care of one industry because there's some political favor that can be won from attacking a particular industry, but then that ends up affecting the whole system. We have to stop thinking narrowly and to understand that the IP system has to operate as a whole, and that we shouldn't just chip away at it for all the wrong reasons.
Yeah. Judge Michelle, take it home for us.
Well, I think we need to go back to basics. The founding idea of intellectual property law was that it was property. That's why it's called intellectual property. And property implies the right to prevent others from using your creation without your permission. We have to redeem patents and copyrights and the rest as actual property that's protectable and sellable and licensable. And among other things, that critically means when the right is infringed, courts have to order the infringement to stop. It's not good enough to later make somebody pay some limited amount of money. They need to be ordered to stop right now. So injunctions have to be revived. No other things will be enough unless you also revive injunctions.
Thank you. Thank you all. You know, we started this conversation with the remarks from the senators. And because it's World IP Day, on the heels of World IP Day, the big focus was on the diversity, bringing in more innovators, more patent owners on the table, numbers of women inventors and so on. And those are great goals. But what you have all highlighted in this panel as experts is that there are these foundations that need to be cemented, almost reaffirmed, and they have been significantly eroded and weakened, which is simple basics. Patent eligibility, getting the patents in the first place, patent validity, surviving those challenges, the right procedures for those, and finally enforceability of those rights. If we don't have those, then we really sort of lose everything else around those pillars that we are trying to build. So this was excellent educational session. I hope we follow up with this with written remarks and more commentary from CSIS. Thank you all for your time and for being here today. And thanks for those who tuned in.